Hello, I'm Catherine Weaver from Weaver Law Offices, and I'd like to talk to you a little bit today about financial issues as you're going through a divorce action. I think what people need to think about and what people need to remember is that all issues as it relates to the finances of a divorce are important to your attorney. And what that means is doing a little bit of homework before you meet with your attorney. Here's what I would suggest. Do a checklist. The checklist should include things like, do you have copies of your tax returns from the past 5 years? Do you have statements, monthly statements from your financial accounts? Do you have a mortgage statement? Do you have copies of your credit card statements? There are numerous financial issues that your attorney is going to need to discuss with you. The more financial information that you can provide at that initial consultation, the easier it will be for your attorney to give you a bird's-eye view of what your divorce financially is going to look like. Now, of course, there are other issues that are absolutely important in a divorce action, such as custody and placement of the children. That's something I'm going to get into later. But in discussing the financial issues, I think that there are some broad concepts that I can share with you in terms of a divorce in Wisconsin that will be helpful to you in terms of feeling comfortable with the process. First of all, Wisconsin is a marital property state, and what that means is if there are no gifted or inherited assets, or if there is no prenuptial agreement in your particular case, you can count on the fact that in mid to long-term marriages, your marital estate is going to be divided on a 50-50 basis. What does that mean? Well, I mentioned two things, gifted and inherited property and prenuptial agreements. The reason that that's important is because gifted and inherited property that has been kept separate is individual property and is not counted in the marital estate and will not be divided by the court. Secondarily, if you have an asset, if you have a prenuptial agreement that is that lists assets that you intend to exclude at the time that you were married, those assets, provided that prenuptial agreement was drafted properly, is going to exclude those assets as well from the marital estate. So the assets in mid to long-term marriages that are within the marital estate, those assets are going to be divided on a 50-50 basis. You should get comfortable with understanding what all of your assets are. Your assets include the personal property, your vehicles, real estate. Most people have a primary residence. Some people have recreational properties. Make a list of the assets that you have in your estate. That will make you feel more comfortable in terms of understanding the process and what there is to be divided. You know, a court isn't interested in who gets what asset. The court looks at it as a marital pie. There's a pie that needs to be divided on a 50-50 basis. What assets you get, what assets your husband gets. The court is not concerned with how you divide that marital pie. What the court is concerned with as a court of equity is that that marital pie gets divided on a 50-50 basis. So start with making your list. Well, you may ask yourself, how do I value things? You can start by using, with your house, the property tax assessed value. With financial accounts, look at the balances on those financial accounts. Now, talking briefly about the real estate, a marital house is many times the most valuable asset in the marriage, and property tax assessments are typically low. Now, we're in a very soft housing market, so that may not necessarily be true right now, but it is typically true of the marital home that the property tax assessed value is low. What will the courts require if there is not an agreement as to the value of that home? Well, they will tell you to get an appraiser, and the court typically has a list of appraisers that they use, and you will select one of those with your spouse's attorney, and that will be the value that the court will most likely and typically put on that asset. Now, there's another aspect to the financial affairs as it relates to the divorce action, much more emotional than the property division, which I think is pretty easy to reconcile, and that is maintenance. Used to be called alimony, it's spousal support. And the question in mid to long-term marriages where there is a difference in incomes is how much maintenance for how long. This is an issue that gets litigated fairly frequently, although I can tell you from my experience that two good family law attorneys who are working to benefit their clients will work hard to come to a resolution on that issue. As I say, this is an emotionally charged issue in terms of you have one spouse that has less income that is very concerned about being able to make it. You have another spouse that has a higher earning power and is saying, wait a second, if I give up some of that higher earning power, I'm not going to be able to live my life the way I want to. These are difficult issues that can be resolved with good attorneys. Now, sometimes cases have to go to trial, and I would tell you that it is important to get an attorney that understands settlement in terms of negotiating something that you can live with at the end of the day, that reasonably settles your estate and the alimony maintenance issue. However, let me say that from my perspective, it is important to get an attorney that understands and knows how to litigate a case. An attorney who has experience litigating. And the reason you want an experienced litigator is because people in the community, lawyers in the community, know attorneys that settle cases and they know attorneys that litigate cases. And if you have what is considered to be a settlement attorney, well, that attorney is going to be pushed into a corner by the other attorney that may be a litigator because they know that ultimately the attorney won't take the case to trial. So what's important is to feel comfortable that you have a competent and knowledgeable attorney, but also that you have an attorney who at the end of the day, if they can't reasonably settle your case, knows how to try it before a court. These are very, very important skills. It is essential that you choose an attorney that has these skills. Thank you.